Sorry, blew up. I hope you heard that last effort.
1803, it looked like the guy in the suit was okay.
Okay, so I really wanted you to listen to this congressperson admitting that they made a mistake. They didn't know what they were talking about. They got suckered in by the banks. And of course, now what he's referring to is the deregulation of the rest of the derivatives. So it's not enough that they're deregulated at 90%, which is already 700 trillion. I cannot believe that he's sitting there telling the rest of these people, wherever he's making this statement, that if we had Glass-Steagall, we wouldn't be talking about it. If they hadn't done the Modernization Act, the derivatives wouldn't have blown up, which is credit default swaps, which is what's blown up everything. And that when they passed that bill, there were 800 billion in credit default swaps, and now there's 700 trillion. And he can sit there and say that. It's absolutely astonishing to me that these people obviously don't hear the screaming and crying I hear from everybody losing their home and getting shoved out of their house, and all the work that everybody is doing for pay or for free to try to stop this mess and monstrous act. This is absolutely an outrage. Now, fortunately, there are attorneys. Now, I wanted to play this real quickly. This is from Martha Coakley. This is Massachusetts. And I want you to pay attention that what she's saying, but remember, this is in 2011. This is a year and a half ago, pretty much when I started my little effort. Listen to what she says, because there's some key points here.
This is the first comprehensive lawsuit seeking to attain accountability and real relief for the bank's role and their misconduct in the foreclosure crisis. This suit seeks accountability against the banks for both cutting corners and also rushing to unnecessarily foreclose homeowners without following the rule of law. That bank conduct includes, and this is in the more than 60-page complaint that we filed, but in summary, that complaint includes allegations about wide and fraudulent use of false documentation in the bank's rush to foreclose on homeowners, commonly known or called robo-signing. Secondly, the suit alleges bank conduct of unlawful foreclosures in which banks began foreclosures without actually holding the mortgage. They continue to behave in ways that affect individual consumers, that affect the economy, and frankly, we think enough is enough. They've been the ones bailed out. They are still behaving in ways that badly affect not only individual consumers but the whole economy. And we believe that without real affordability for loan modifications and accountability by the banks, we're not going to solve this foreclosure crisis, and we're not going to get our economy turned around. Even if the banks think they are too big to fail, they are indicating to us that they think they're too big to care about the devastation they're creating every single day. And we believe that they're not too big to have to follow the law. This is the first.
Absolutely. We totally agree that they're not too big to follow the law. The key is, this is in 11, and I swear that her charges, did you hear what she said? She's talking about robo-signing as if that's all they did on the false foreclosure documents. And that's because I believe most of these people really did think they bought into the bank story, that was the main problem, that we just got a little ahead of ourselves in the process. Not the fact that it was actually false notarizations, that you had notaries or people just signing notaries' names that weren't the notary to notarize other people signing someone else's signature, which is complete fraud. But they also didn't understand that in the generation of these documents, they violated all the laws and common sense. So they would have, we've talked about this, and I'm going to show it again right here, real quick. Remember, this is on the workshop, the recorded document workshop. You go look at that workshop if you don't understand what I'm talking about, because I don't want to take much more time right now. But you see, right here, you've got Bank of America, which is a lender, which was given the rights. And that's illegal from MERS. MERS gave Bank of America servicing the rights, assigned the rights of the loan, and that's illegal according to federal law. And then you've got the Bank of America assigning it to the trustee of the mortgage-backed security, and that is completely fake. And the people don't get it. Now, that is the heart of how we're going to stop this. And the reason I say that is because I've got attorneys that are using these kinds of lawsuits and lawsuits about the fraud. If you can get that lawsuit into court, they are winning. So this is very much the heart of it. So let's pay attention and focus on how we can use the fraud. This is the point. I have been saying for years, when the common person, besides the prosecutors and the defense attorneys, but when everybody, the people, understand the level of fraud and forgery, they will say that's not robo-signing. No, that's conspiracy to commit forgery, and that's conspiracy to take my homes and to cover up your asses on these credit default swaps. That's what it really is. I just have to play this for you. It's just a minute. You got to hear Bernanke admit they don't know where the money went.
On the benefits of being too big to fail, no, we don't have an estimate. It's pretty difficult to control for all the factors that go into determining the size of the subsidy. I think there is some evidence that financial markets are, at least to some extent, taking into account the possibility that large financial institutions will fail. You see, for example, spreads in the credit default swaps that indicate some probability of failure. You see some discrimination among different institutions according to the bond market interest rates that they get charged and so on. So there is some evidence of market discrimination. That being said, I certainly never meant to say to Senator Warren, and I share her concern about too big to fail. I think it's a major issue. I never meant to imply that the problem was solved and gone. It is not solved and gone. It's still here. But there's a lot of work in train. We're putting in the Basel capital standards. We're putting in the Orderly Liquidation Authority from Dodd-Frank. We're working with our international partners. And I hope that we'll make progress against too big to fail, because I agree with her 100% that it's a real problem and needs to be addressed if at all possible.
No kidding. I wanted to bring to your attention Judge Shack in New York, because what he did in October 2012, and this is laying the basis of bank sanctions. This is the first time I saw anything in a ruling where they actually said, wait a minute, what you are actually doing is fraudulent and wrong, and why shouldn't I sanction you? Says the judge to the banks. This is an IndyMac federal bank lawsuit against these defendants, and this is what I call the vampire ruling, because in this particular case, and the link will be there, you can read it at your leisure, but basically the court granted relief to the defendants because in this case the plaintiff IndyMac lacked jurisdiction because it ceased to exist. It died March 19, 2009, almost 3 weeks before the action commenced. If plaintiff IndyMac Fed has jurisdiction in standing, it would be the legal equivalent of a vampire, the living dead. Further, the court is concerned that there are documents in this action in which various individuals claim to be the officers of either the living dead IndyMac Fed or its deceased predecessor. Notice, IndyMac Bank FSB. Remember, they always play this shell game. You got to pay attention. Every little difference makes a difference. It's a different corporation. And the law firm of Fine, Such and Crane commenced and prosecuted this meritless action, asserting false material statements on behalf of a client that ceased to exist 20 days prior to the commencement of the action. And that is the key to getting the rights for the people reestablished. That is the key for getting the houses back, for getting restitution, for proving fraud and forgery. And here, the judge wants to get the attorney firm an opportunity to be heard as to why the court should not sanction it for engaging in frivolous conduct. So we're going to hear from Lorraine here in just a minute and get her input on how she's written her bank sanction. I think it's really exciting because as the people work together to fight back, we really have some chances. And so before she comes on, I'd like to share with you, this is Matt Wiedner arguing in front of the judge for bank sanctions. This happens to be an appeals court, and he's appealing. The lower court ruled for the bank. He's appealing that on behalf of his borrower, and I really wanted you to hear what was said here. Oh, excuse me, I got to back this up here. Sorry. Here, we'll start right here.
My client being no different. I mean, they're having trouble with their mortgage. They don't have money to stop this volume of paperwork thrown at them by the banks. When the banks play hide and seek with the truth and equity, there should be a sanction. I have now spent over 3 years on this case, or thereabouts, since 2009. But it's not right that a borrower is faced with going by way of default. I understand over 30% go by way of default. When there's $897,392,000 worth of these notes they can do that with, they're making $300 or more million just on defaults. And no one knows whether they were right or wrong. I do not give them. Now, I cannot give them excuse. I believe it should be sanctioned. I believe that we stop this conduct with the decision by the 2nd District Court of Appeals. The congestion will go down by 50% or more. This is a game they've been playing. They've never been sanctioned. I don't think I found a sanction more than $750,000. And if they only got sanctioned $750,000 twice in every 100 cases, they would net out. If they mortgages average $200,000, they'd net out $18,500,000 profit with not having to prove their case. If they got sanctioned $750,000 twice in every 100 cases, and I've only found 1 or 2, I believe I might have quoted the AmeriQuest case. But I just asked the court to consider, and I made the scriveners there. I said my motion for sanctions, I have no sanction power. This court has the inherent authority and equity that finds this conduct as outrageous as I do, and it has the ability to sui sponte under Rule 57, Statute 57-105, first paragraph, I believe, gives the court when they find something. And I believe this is not dissimilar to the Pinot case up there before the Supreme Court. It was involved in bogus mortgage.
Thank you.
Thank you.
You're welcome. Thank you both.
That last little bit, what Matt was saying, I'm not sure you could hear, but he was saying that other case, it involves missing and fraudulent paperwork. That's why he's begging and challenging the court to give sanctions to the banks, because this is what they're doing. This is how they're messing up, and it's significant. They, like Martha said, they don't have the paperwork. They started the foreclosures on mortgages that they didn't even own. And of course, you and I know that this happened over and over and over and over and over. And as Lorraine's on the line, I'm going to invite her in just a minute, but I wanted to show you that a bank forges the note, and in this particular case, this was just done March 7, 2013. In New Jersey, this foreclosure case was dismissed. It took 4 years in court. That's another reason that it's taken so long, is because since the Department of Justice has been bought off by the banks, the Fed is in the bank pocket, Congress obviously voted for the banks, whether either they didn't know or they did it intentionally because they get money. The fact is the people have been looking for other restitution and recourse, and they've had to go to court. And court takes a long time. And here, in this case, these people had an attorney that understood how to present, in their case, the fraudulent and missing documents. And so they got it dismissed. Let's invite Lorraine. Hey, Lorraine, this is CJ. Welcome to the show.
Thank you.
So, how are you doing these days?
I'm doing okay.
And you, what I asked you to come on the show to talk about was sanctions for the bank. So before you explain what you're doing, if and when you win, who gets paid on these sanctions? Is that for you? What happens? How does that work?
Okay, I believe the court has to sanction the actual banks, and they have to pay the court.
All right. So your effort on bank sanctions won't give you some money. It would give the court some money.
Correct.
Because that's one of the objections. As soon as I sent out the little update today about, we're talking about bank sanctions, I just wanted to read real quickly. Somebody says, but they email back, who gets the money? The courts, the states, the attorneys? How about the victims? And if sanctions actually happen, are the taxpayers going to have to pay those sanctions? And when do the arrests start? That's what everybody wants. When can we put them in prison? And that, of course, is not the topic of today. Unfortunately, neither Lorraine nor I have power on that part. But Lorraine, why don't you tell us now what you're doing about the sanctions and what that process is? Just bring us up to date, and then I will pull out your documents.
Okay, well, first of all, the attorneys are representing the bank is an attorney firm called Reed and Smith, and they're out of Philadelphia. And they filed a motion to dismiss my amended complaint. And in their last filing, they had so many inaccuracies that when I was trying to write my opposition to their motion, I realized that if I don't point out that all these are actually violations because they're false statements, and that, and plus the evidence that I had on them for filing the fraudulent foreclosure, I realized I actually had enough information to actually file a motion for sanctions. And so I looked up how to do that, with the Pennsylvania code, how to look up the proper way.
Okay, so basically in your particular case, there were so many problems with the case, so many lies, so many cheats. You decided this is nonsense. How can I even respond? I need to file for sanctions. So I've got your lawsuit up here. Why don't you explain to us what it's talking about?
Okay, you actually have my opposition to motion to dismiss, which is kind of like a rough draft.
Okay.
I sent them. If you can find the other one that I had sent you, it says notice of violation, which is what the first thing I sent to them, because you have to send them notification, not the court. You just have to I sent to the attorneys. I point out everything that they violated and ask them to cure it. That's the first thing I had to do. And so the false statements, I point out the fact that they cannot claim that they are not debt collectors that's defined under the FDCPA, which is something that they had, made their whole claim in their motion to dismiss list. They tried to falsely state they were not debt collectors. However, we all know they are debt collectors under the FDCPA.
Right.
They're trying to twist the law to their benefit, and they can't do that. I mean, they can't file a motion to dismiss arguing the same argument from a previous ruling. We had already brought that up from a previous ruling, and the judge had decided that my case did survive the Rule 12B motion to dismiss. Therefore, they can't bring that up again, and they did. So that's kind of like another violation. And then I brought up the fact that they keep putting fraudulent documents in the court and fraudulent representations into the court.
And you were asking to have the objection to admissions. Is that what you were asking for?
No, that
Which
was
one?
something else that entirely that was something that I filed against one of their attorneys for something they did wrong procedurally. Since if I don't get them for everything they do wrong, that's what they try to do to us is try to dismiss us. But they do it in a fraudulent way. I'm doing everything legally.
Right.
I'm pointing out to them, I'm following the law, I'm citing case law, proving my point. I thought I sent you the
What's it called again?
notice of sanctions.
What was it called again?
Notice of sanctions, and I'll
Okay.
send it again.
No, I think I've got it. Is this it? Notice to defendants of violation and impending sanctions?
That's it.
I found it. Great. Okay.
Okay, that's what I sent them. I didn't file that in court. I just mailed that to them, certified mail.
Why would you do that?
Because the law states that I have to give them 28 days to cure their defects. I have to send them notice telling them what their defects are, allow 28 days for them. They can correct their mistakes and not get sanctioned.
Got it. Okay. So
You have to, under
right.
Pennsylvania law, you have to figure out whatever your state law is, and I followed that, and it states there on the first page on the bottom, that first footnote, I believe, explains.
Right. A motion for sanctions. And I like what you said here on the top of page 2. In the United States, when an officer of the court is found to have fraudulently presented facts to court so that the court is impaired in the impartial performance of its legal task, the act known as fraud upon the court is a crime deemed so severe and fundamentally opposed to the operation of justice that it is not subject to any statute of limitation.
Yeah.
And
I thought
so
that was good too.
you're great. This is truly just great. Okay, so what you've done now then is started to itemize this misinformation that they've given to the court.
Right. And number 1 states that the memorandum of law in support to their motion to dismiss that was filed, document 46, contains the information that is inaccurate to such extreme that it alone would be considered fraud upon the court. I mean, that's the first thing I pointed out to them.
Right.
And then I point out that, that they're trying to dismiss it, stating they're not debt collectors under the FDCPA, which is a false statement.
Right.
And then, and I brought in the case law to back me up on that at the bottom of that.
Right.
It's a good case, by the way. Everyone should have that one. Bridge versus Ogwin. If you want to argue the FDCPA, that's the case to look at.
Excellent.
Okay, and
yes.
then after that, I explained that because they tried to dismiss my case under the Rule 12b-6, failing to state a claim that relief can be granted. This rule only applies to lawsuits with insufficient legal theories underlying their cause of action. Okay, when I had presented them with plenty of facts to back up everything I was saying, plenty of exhibits, attachments, and evidence to support it, so they can't get it dismissed under the Rule 12b.
Right. They're basically saying she doesn't have a case because she didn't cite anything.
Out that by them bringing it up again after the judge had already ruled it, you see there it says res judicatica, is that how you say it? Between these specific parties applies. That's the bottom of number 4. That's the legal term. Res judicatica.
I don't see where we're on.
At number 4.
You're talking about item number 4?
Yeah, number 4.
Yeah. Oh, right here.
Read the very last sentence of number 4.
Yes. Therefore, res judicatica, between these specific people.
Right.
And
I had to look that one up to see what it
Judicata?
means, but they can't bring up something that's already been ruled on, and they did.
right. In other words, they just keep rehashing the same old.
Exactly, yeah. And that
Judicata.
is also frivolous. When they do that, it wastes the court's time, and it's considered frivolous, and that action alone is justifiable to sanction.
Right. And then, of course, not only do the defendants admit, but they brag or claim over and over and over that they're debt collectors.
I know, and not only do I have it in writing as proof, but
Yes.
if you call their customer service number, the first thing that comes on their IVR is we're a debt collector.
Right.
Now, if you've ever gotten a foreclosure notice, the second page says that they're a debt collector.
Right. And everything that is being sent out, people will send me, mortgage statements, all kinds of stuff, and it's stamped on everything that they're debt collectors.
Right. I mean, who are these attorneys representing? That's my, was thinking, well, wait a minute. If they're saying they're not debt collectors, then is this a different Bank of America we're talking about here? No.
Probably. They're probably going to play the corporate shell game. Let's make another shell, and let's make that not the debt collector that goes in and sues for foreclosure. The whole thing is fraud.
And then going to number 7, I brought up the fact that they committed perjury, by swearing.
Right.
When they do a foreclosure notice, they have that fake vice president of the bank, which in my case was Matthew Thomas Stevenson, was the assistant vice president of Bank of America, which on the form they claimed it was Bank of New York Mellon, which was like double fraudulent forgery stuff there. And, how can they say this? Oh, under oath, blah, blah, blah. How can they sit there and outright lie like that and get away with it? I don't know.
Well, probably, Lorraine. I mean, seriously, here's the point. It is an assembly line. They do have just people at $10 an hour sitting there and signing other people's names and stamping notary stamps, I swear. And if the Bank of New York Mellon actually knew that this person was claiming to be a VP, they'd be enraged, because that's not true at all. You and I know that. They're getting away with it because what they've been doing is in secret. They have this assembly line. They either record it with e-record, they send it electronically, or they send it in an envelope to the recorder's office. Nobody there has any authority to actually review documents and see if they were legal or not. They just record them. They just stamp them and stick them on file. And so they've been able to do this so long and get away with it. They don't even really think anything more about it. I mean, you're just a thorn in their side. You're just not. You're not falling over like you're supposed to.
I know, right?
Exactly.
But see, I have a lot of things in my favor. I'm in a judicial state. Pennsylvania is one of the few states that has some good things that are going on, like the recorder of deeds. Is getting stuff going there.
Right.
And so I have a lot of stuff to back up my claims. Plus, like I said, I actually have the documents, which I showed them. They have yet to even acknowledge, because they're saying that they're just not even debt collectors that are under the FDCPA. So their actual argument is, we're not going to talk about any of your claims that you brought on your amended complaint because we don't even, we're
right.
They're trying to throw the whole thing out, saying that, well, we're not debt collectors under FDCPA, so we don't have to answer to any of your questions.
Right.
So they committed fraud.
See, you know what this reminds me of? This reminds me of MERS. Because in all the deeds of trust and all the mortgages, in all of these toxic loans, they basically said in that same paragraph that MERS is the nominee, it's the rabbit, we're just the nominee, we just do what we're told. And then they say they're the beneficiary, we're the owner, and so they want to play whichever side. We've covered both sides, they're completely opposite, but we have both sides covered, and this sounds like what they're doing here. We're going to be a debt collector when it suits our purposes. And then, when we're foreclosed, oh, we're not a debt collector, I'm foreclosing because you didn't pay your note. They're trying to play both sides.
Yeah, well, the Uniform Commercial Code, I didn't bring that up on this, but I'm bringing it up when I file my opposition.
Yes.
And motion for sanctions, because I'm going all the way with these people, is the Uniform Commercial Code states specifically that the holder in due course, and you almost have to bring up the definitions of all these things, but
exactly.
If it shows any evidence of being altered or forged, it becomes null and void, and so the person that supposedly gets that assignment of mortgage doesn't get it.
Right, exactly. No foreclosure, no transfer of title in any way, shape, or form. And this is true in every state in the union. And it can be valid if it's based with a forged signature or a false notarization, much less some kind of a fake beneficiary name.
People need to remember to use that argument, because seriously, if you can show evidence of forgery on any of that stuff, they can't legally foreclose on your house because they're not the holder in due course anymore.
Well, see, and we know that's true. The kicker has always been, how do you get that into court? How do you get that into a lawsuit, particularly in a state that's not a mortgage state or not a judicial state? It's a deed of trust. It's just a process. They just send fake documents to the recorder's office. It's recorded. They take the property back. They boot you out with SWAT. And how do you stop that? That has been just really the violation of the people. And at least...
I would think, honestly, at this point, since there's so much criminal activity with this robo-signers and fake notaries, if
Exactly.
you can prove fraudulent documents were actually, and you can look up the actual crime, you could probably go to the DA's office, the sheriff's office, and have them actually serve the person with criminal charges.
Okay. And one of the problems, yes, on the notary and maybe the signer, the notary at least has a county of record, a state and a county of record. The signers, we don't even really know where those people are, if they, the people that signed are actually the real people anyway. That is true. You can actually send like your notary complaint to the district attorney of that county. Whether they'll do something with it or not is hard to say. One of the problems is that even though you're doing that, since that's a separate process, the foreclosure trustee, Recon Trust, they just take the property anyway. That mechanism just grinds on. That's one of the huge problems that people are facing. Now, there's attorneys that I've got coming on the show later this week that actually have developed lawsuits based on this securitization fraud. The fact that they did not complete the securitization, they do not have standing. It's basically an argument that the court could recognize that the bank, the foreclosing entity, does not have standing. And the point is to stop the foreclosure and then to help the homeowner keep the house. Where those are going, how that's working, we're going to be hearing from these attorneys and others about the process and the satisfactory conclusion of these kinds of lawsuits, because I believe that that's probably about the only thing that people have left right now until we can get some of our elected officials to step up. So, Lorraine, let's continue on the other issues that you've talked about here. Oh, now you talk about the money. On item 12, you said you made the claim that they've used money to pay off a mortgage loan, and that isn't true. What are we talking about on that one?
Okay, I found out that, and this is just my situation, but there was a bankruptcy proceeding with my ex-husband where he had actually claimed the mortgage with Chase, and it was declared as part of the bankruptcy, and it was discharged in 2004. And I actually looked on my county records, and I found that Chase filed a satisfaction piece after that, before this mortgage with Countrywide started. So there was a, so actually there was no debt. They can't claim that they paid off. They said that they claimed $97,000 was paid off for an existing mortgage with Chase, but that was actually discharged. So that's a lie. Again, another lie.
Another lie. They're going to lie wherever they can. That is their business model, by the way. They just lie. Lie, cheat, steal.
Right. So again, I actually attached a copy of the discharge, a copy of the satisfaction, and a copy of the quitclaim deed, which is proof to back up my statement, proof to back it all up there, Exhibit B. So I mean, they're not supplying anything. They're not giving me copies of the original loan documents for me to even inspect to see if they even have the original promissory note. Yet I'm sitting there and giving them all these exhibits proving my point. How can the judge not see that I'm the one that's being honest here?
Well, yeah, and that is a huge question, and I have already mentioned this frequently, and for whatever reason, and there could be several, but I have seen specifically, and when I see this in judge responses, like we've watched some of these pleadings and judge responses, like with Matt, if you watch that whole episode, that one or another one, I forget now which one. But the fact is, when the judges get a whiff that if they make a ruling for you, for example, on this or on, in some case, that would actually affect, if you will, a whole class of borrowers, like in this case I'm thinking of, it happened to be a loan owned, theoretically, by Fannie Mae. And one of the judges said, well, Fannie Mae owns millions of loans, and you could just feel the electricity suddenly ramp up in the judge's thinking. If we made this decision for the defendant in this particular case, is that going to open the door to millions of people not paying Fannie Mae? And I'm confident that there is some real serious discussion and mental process on the part of the judges about these kinds of lawsuits. And the fact is, these attorneys that are representing foreclosures, and we've got some strong ones coming on the show, they have had to figure out how to deal with that kind of, if you will, knee-jerk reaction. I don't care if you have the best case on the planet. I'm not going to rule for you because I'm afraid it would open the door and it would destroy our economy. As if the economy hasn't already been destroyed.
Right. Right. That's why it's important when you plead these cases is you really have to have some really good cases to back up your case.
Right.
And there are some good ones out there. Believe me, this is just the tip of the iceberg.
So tell us a little bit about the Kuntz v. Potts. That's on item number 15. That's evidently a ruling about the attorney to certify to the court his client's claims, defenses, the other legal contingents are warranted.
Oh yeah, that's actually worth looking up. There's the judge had sanctioned Bank of America $300,000 because how the company handled a woman's foreclosure. Trudy Crutchfield was her name, and basically they tried to foreclose after she had bankruptcy. And so basically, if you read the footnote down there, you'll see that the judge had ordered the company to pay her $300,000. Like in this case, she got money, right? And company has to pay within 30 days, or the amount doubles.
I wonder if they paid. I really do.
And then it even says that if they don't fix her credit within 90 days, the company has to pay an additional $300,000. So in this case, the judge really came down harshly on Bank of America with this sanction.
And then the issue is, how do we get the judges to do that for everybody, basically? Wow. So that's a real good case to...
So that was a good one to attach to my case as being here's a sanction showing the judge had enough of Bank of America's bullshit,
Right, exactly. And that is just like what I'd showed quickly about Judge Schack. These attorneys are filing a foreclosure lawsuit and claiming to do so under the hat, if you will, of a corporate entity that is completely gone. It's what I call the defunct lender. The lender's gone, so who cares? Let's just file foreclosure. And I'm positive this is just standard operating procedure. What we're seeing in these courts is just the baby little tip of the iceberg, because we already know this is how they do it. So where else are? Oops, here we go. We're almost done. So, right, you re-point out that the defendants are debt collectors. And now, you sent this to them last week, right?
Yes.
And so they're saying they have 28 days. So that puts you into April sometime?
I actually got an email back from them telling me that they do not concur.
Oh, well, of course. Duh. So what does that mean?
I had to file a request for additional time with the court, because I should have had, I should be able to file my opposition motion by tomorrow, but because I had sent them this, I have to wait 28 days for this, so I asked for additional time from the court. I don't know if that'll be granted or not, but I'm going to at least try.
Why wouldn't it be granted? Would the court act?
I don't know, because I have no idea why it wouldn't be granted. It
Right.
just seems to me that that's the proper way to do it was the way I did it. But just letting you know, sometimes circumstances come up that you have to remember. Okay, well, I have to file this by this date. I have to remember to, if you're doing this yourself and you don't have an attorney, you have to follow the rules of the court. And I had to follow the court rules by filing a request for an extension of time. I would assume they're going to grant it, but if they don't, I'm still going to be ready anyway.
Right. And so assuming they grant it, and then assuming that the bankster doesn't concur and they don't respond, then what's the next step?
Okay, I'm still going to file I have to file my opposition to their motion. If they let me have the additional time, then I'll use that additional time to really make a much better pleading. If they don't, then I'm still ready. I'll file it, and then after 28 days, then I file my motion for sanctions. They're not going to get away with it either way.
Right. They'll delay. And have they ever, Lorraine, have they ever talked to you about buying you off? Have they ever contacted you and saying, okay, look, let's just settle out of court?
No, and you know what? They're having trouble getting my original loan documents for discovery.
Of course they are. You don't think they have any documents, do you? Oh, my goodness.
If they want to settle, they did talk about did I even think about it and stuff, and I'm like, well, I'm not even sure if you're the correct party.
Exactly.
That is the correct, person I even owes my note, because I told them, I said, how do I know you're the right party? You can't even get a hold of my original loan documents. I don't know if I've even paid the right person all this time.
Exactly. And so I'm positive you've sent I'm positive you sent the qualified written request. So have you gotten any information back from that?
The QWA was sent over a year ago. I got an attorney's letter in the mail that sent me a bunch of statements showing all the payments I made, but it wouldn't show the correct amount that was credited.
Right.
And then when they filed their foreclosure, the amount that they were asking was ridiculous. It was like $5,000 over what I had started from the beginning of the loan.
Right. People get this all the time. It's like they bulk up all the fees and everything, and they just plop it onto the principal, and there's never any accounting. That even those that are desperate and have been offered a loan modification cannot get an accounting of where did that money go. And this is one of the really scary things. I believe that nobody really knows. I think it goes into a slush fund offshore, frankly. That's what I've been told, and that makes perfect sense. They're not going to make it to a payment because the loan was paid off. Insurance, they paid it. So they're just coming after you for extra money. They don't know where it's going to go. It's not going to go to your loan, even if you picked up payments, that's for sure.
Right, I know.
And that's the dilemma, because without being able to just stop them. Now here's the point. Your lawsuit in court has actually delayed the foreclosure process?
Yeah, basically it has, because they tried to file a foreclosure when I already had this case in the federal court. They tried to file my foreclosure in the state court, and that's like a conflict of interest. They can't do that.
And so you had to stop that somehow?
Yeah, I just filed a motion to dismiss, explaining that I already had a case going on in federal court, so they had no right to even file that.
Right. And so if you hadn't known that, possibly they could have just continued in state court, filed away, and taken the house, even while you're fighting over here.
Because the sheriff showed up at my front door and handed it to me, so it's not like I didn't know,
Okay, all right. So you have this. So at least you were able to respond and get that dismissed.
Right, and then later I find out that the actual first page that the lawyer firm, if you look at that, it says that they're foreclosing in behalf of Schwab, the Bank of New York Mellon, and then they said that their address, and that address I Googled, doesn't even belong to Mellon Bank.
Right. they do this all the time. You know, if you have any questions about the your payments or anything, then they say the, you know, New York Mellon, but then the contact information is obviously the servicer who's trying to foreclose. They're just using, I swear.
That's a huge false statement. The very first page
Exactly.
is a huge false statement. They're pretending they're someone they're not.
That's right.
And they're saying they're not a debt collector when the first page says they're a debt collector. So,
Exactly.
And, you know.
Well, and that's that. And see, this is what some of these attorneys are actually able to get into court and start to win with, start to get some leverage. And that is all of this, what I call a false dichotomy. It's just a mess. They call themselves everything. So I can be this or I'm going to be that. I'm going to be a debt collector or I'm not a debt collector. You know, Bank of New York Mellon owns it or I own it. Whichever one's going to work is what they're going to pick. And this is the fraud. So when all of these people, I played these little clips this morning, both the Congress people, even Martha Coakley, they're talking about the robo-signing. I'm confident, that was in 2011, I am confident that all the people, even the prosecutors, because I know this for a fact, when I speak to the prosecutors in the Attorney General's office, they have not grasped the depth of the fraud and fakery on all of this paperwork. They were, if you will, sold a bill of goods. I'm sure the banks came in, wined and dined them, contributed to their campaign funds, and said, you know, yeah, we had some processing problems. It's not that big a deal. And you know, that sounds good. I mean, I'm reminded of that little song that I play in the morning where it says, I really wish I could tell you things weren't this bad. and that's, the banks are saying, it's not that bad, trust me. And the people are going, oh, okay. And now Congress and the prosecutors, I know many of them are saying, wait a minute, you guys have completely run amok and this is completely out of hand. Now we're behind the 8 ball. How do we try to prosecute these? And it's up to leaders like you, Lorraine, to show them how.
Yeah, I mean, here it is. I'm going to do it. I'm going to go run the whole mile distance here. I'm not going to go out of this saying, well, I could have sanctioned those banks.
Yes.
You know, if I lose it, even if I lose at the end, I'm going to say, well, at least I did everything I could possibly do.
Absolutely. And we're totally behind you. Thank you so much for sharing. I really appreciate it this morning. I know you had a surprise snowstorm today. So
we sure did.
You might consider a nicer state for weather.
Yeah.
Thanks, Lorraine. We're going to have to sign off. And we really appreciate your contributions. And good
You're
luck.
welcome.
Keep us posted. And as we have been wont to do, we are going to close with our favorite group, Booger the Bankers.
Okay.
And we'll see you tomorrow, everybody. Thanks for joining us. And don't pay attention this week because we've got some really cool attorneys joining us. See you for now.
When I was a lass, I was proud of me class, like my father and mother before me. They taught me to fight for my civil rights, but it's always the same old story. The rich reign supreme while the poor can but dream, and the labor all liberal or Tory.
System is bent and the money's all spent. We're murdered from every direction.
The workers get taxed while the wealthy